Good afternoon, Justices of the Court. My name is Lorestani, initial J, and to my left is my colleague Brklacich, initial K, and we are here on behalf of the appellant, Ms. Kathy Gauthier, in the case at bar. It is the appellant's position that the Supreme Court of Canada erred in its application for the test of the defense of abandonment, and we are respectfully requesting that this court overturn the conviction of first-degree murder. If this honorable court finds no reason to overturn the conviction, in the alternative, we are respectfully requesting that the matter be remitted to trial to allow Ms. Kathy Gauthier to present new evidence as the steps she took to neutralize her involvement. Would your honors require a brief summary of the facts?
No,
Thank you very much. The appellant has 4 submissions to make today. Our first submission is that the Supreme Court of Canada's decision in Regina v. Gauthier was not in line with previous jurisprudence. Our second submission is that public policy considerations regarding the administration of justice do not warrant the alteration to the defense of abandonment. Our third submission is that there is an error of reality to the element of unequivocal communication in the case at bar. And our final submission is that the newly added neutralization requirement should never have been applied retroactively to Ms. Gauthier. I will be addressing the first 2 submissions, and my colleague will be addressing the last 2. Decision after decision in judicial history following the British Columbia Court of Appeal decision of Rex v. Whitehouse, Justice Sloan established 3 essential elements to be met: a change of intention, timely notice, and unequivocal communication to the principal offender.
Counsel, I think your friends would have issue with that framing of Justice Sloan's finding in Whitehouse. He really focused on breaking the chain of causation and did not outline a exhaustive 3-part test. Isn't the type of contextual analysis that Justice Sloan focused on exactly what the court below found in requiring the neutralization element?
If I could refer your honors to paragraph 8 of the Supreme Court of Canada's decision in the case at bar, Justice Sloan states, and I quote, "I would not attempt to define too closely what must be done in criminal matters involving participation in a common unlawful purpose to break the chain of causation and responsibility." In that same paragraph, he does continue to say that what must be done will differ as it is a case-by-case analysis. This analysis of neutralization or proportionality has always been a matter of fact analysis, an element that has been put to the jury to decide whether or not someone, an accomplice, has done enough to morally exculpate themselves. This factual analysis has been transformed into a question of law for the judge to evaluate before it even gets to the jury, not to acquit, your honors, just to hear it. That is no longer reformulation of the test. That is new law. While the Supreme Court of Canada has the ability to change laws as they see fit, it must be aligned with public policy considerations for the defense of abandonment. The public must know what the law was, what it is now, and how it affects them going forward. Which now brings me to my second submission. There are 2 public policy reasons behind the defense of abandonment. The first public policy reason for the 3-step test Justice Sloan established is to ensure that only morally culpable persons are punished.
But somebody who commits a crime is morally culpable. This is a question of whether or not they are excused from that culpability.
The neutralization element.
A defense of abandonment is an excuse as opposed to saying you are not culpable.
Your honors, the defense is not an excuse for an accomplice to get away with a crime that they have committed and have not attempted to withdraw themselves from the criminal enterprise.
But they have committed the crime. They committed the actus reus with the mens rea. They could be prosecuted. It's just that they've done something that excuses that behavior after the fact.
Yes, your honor. And when we take that into consideration into the case at bar, Ms. Gauthier attempted to withdraw herself from the criminal enterprise. She had repetitively told her husband that they cannot do this, that it was crazy, and she will be no part of the crime. Furthermore, she took one step to ensure that he understood her by tearing up one handwritten copy of the will and her husband's life story.
But she did all this after procuring and providing him with the murder weapon. So when somebody has actually carried out an illegal act that in this case led to a first-degree murder, multiple murder, then why is it not right for us to punish that person? Why is it not right for us to have a high bar on the defense of abandonment?
The standard of the defense of abandonment will be higher than the error of reality test. However, the jury in the case at bar did not get to hear her defense. What the judge had done, the trial judge had done, is assume that the defense was not available to Section 21 Sub 1. And by the time it got to the Supreme Court of Canada, Justice Wagner and the majority said that the error of reality cannot be met in the circumstances and imposed a new legal threshold and a legal burden for an accomplice to prove that they've taken neutralization steps, something that has been put to the jury since 1940.
So, counsel, you started this argument with a public policy concern that perhaps the defense of abandonment is, in part, aimed for punishing those who are morally culpable. Doesn't requiring neutralization further that goal?
Your Honor, the newly subjective element of neutralization, it creates uncertainty in the law. It creates confusion to the public. They are not aware of what they must do to withdraw themselves in order to have the defense available to them in the first place.
Isn't it quite clear? I mean, she could have done any number of things. She could have taken the pills back. She could have called the police. She could have sent the kids to the neighbors. She could have done any number of things, any one of which would have potentially prevented this crime from happening.
That brings me to my second public policy consideration. The second public policy consideration is that once an accomplice withdraws from a criminal enterprise, the principal offender may be encouraged and reconsider their involvement in the crime itself.
Counsel, that's a nice idea. It clearly didn't happen in the case of the Gauthier family, obviously, because we have a bunch of dead bodies here at the end of the day. So you seem to be telling me that we think it's going to be more likely to make people withdraw from crimes if we make it easy on them. I think your friends are going to say that on the test that you're submitting, individuals need to meet in order to withdraw. You made it so easy that essentially people had to do nothing. Wouldn't the test that your friends have put forward, which would require people to undo the contributions they've made to crimes, wouldn't that result in less dead people? And wouldn't that be good public policy?
Yes, Your Honor, it would be great public policy. However, it is not the appellant's position that the neutralization requirement should not be considered in its totality when it is put to the jury. It is the appellant's position that it should not be a question of law to be considered prior to getting to putting it towards the jury in the first place.
But the error of reality test is about essentially acting as a gatekeeper function. Could a jury potentially acquit on this basis? So surely the judge should be considering everything that the jury is considering, just not considering the credibility and the likelihood of that being believed. So everything that goes to the jury should still be material for the error of reality test as well.
To address the two issues that you have raised, the error of reality test is not some evidence or any evidence. It is evidence that is reasonably capable to support the inferences of the defense, in the case at bar, the defense of abandonment. Furthermore, when we consider the totality of the evidence, the Supreme Court of Canada erred when they did not consider all the evidence that Ms. Gauthier put forward. They simply only focused on her principal narrative provided to us in her direct examination. However, we have more evidence on the record to demonstrate that in her cross-examination that she did indeed withdraw, and she withdrew unequivocally.
But counsel, my concern is that if we say that something is only available for the jury to consider and not the judge, isn't that essentially allowing defenses to go to the jury without having been considered about whether or not they're a viable defense by the judge first.
That is I see that I have now run out of time. May I address your question and conclude? Thank you. The judge does act as a gatekeeper, which is why we do have the error of reality test provided to us by Regina versus Jenous. However, the threshold is a reasonable threshold. The evidence on the record demonstrates to us that she did, in fact, meet the error of reality test. She had nonverbal communication of withdrawal. She had verbal communication of withdrawal. And if, in fact, the court today does find that the newly added neutralization requirement is required and permits it to go back to trial, she will meet the neutralization element as she was not able to provide all the evidence that was tendered, but she may be able to meet that element after all. Thank you very much. May I make my concluding statement?
Yes.
Thank you very much. The appellant requests that this honorable court be the first and last court to provide Ms. Kathy Gauthier with real and a fair outcome since 2009. Not only did she abandon this crime, but our justice system abandoned her for 7 years. Barring any further questions, that concludes the first two submissions on behalf of the appellant, and now my colleague will address the last two submissions. Thank you very much. Good afternoon, honorable justices. My name is Brklacich, initial K, and I represent the appellant, Ms. Kathy Gauthier, in the case at bar. I will be addressing the final two submissions on behalf of the appellant, the first of which is that there is an error of reality to the element of unequivocal communication in the case at bar. Should the law require the neutralization element for the defense of abandonment, it is the appellant's position that Ms. Gauthier has put forward evidence that is capable of satisfying this element as well. The appellant's final submission today is that this is the first time the Supreme Court has imposed a neutralization requirement for the defense of abandonment. Therefore, it should never have been applied retroactively to Ms. Gauthier's evidence.
Was it mentioned in the Fournier case? The neutralization requirement?
In the case of Regina versus Fournier, there was a discussion of proportionality. However, in the case of Regina versus Fournier, the jury had the opportunity to hear the defense and to analyze on the facts of whether or not the accomplice had done enough to satisfy the defense of abandonment and withdraw from the crime.
Justice Wilson as well in Kirkness does discuss quite in detail the addition of neutralization step as well.
Correct. In the decision of Regina versus Kirkness, there is a discussion of proportionality and neutralization. However, it was a discussion, it was not adjudicated upon, and the defense of abandonment in that case utilized a three-step test.
It seems like when we consider how infrequently the defense of abandonment is raised, and these discussions, as you're calling them, perhaps the door has been left open, and this isn't really a new step, more so a reformulation of a door that really has not closed on forming an exhaustive list of criteria.
The defense of abandonment has never explicitly contained a requirement for neutralization. To date, it has always, up until the case at bar, it has always required three essential elements that an accused must satisfy. Furthermore, this is not the first time that the Supreme Court has had an opportunity to analyze the defense of abandonment for a Section 21 sub 1 case. In the decision of Regina versus Bird, there was, the accomplice did use the defense of abandonment.
But in that case, it failed at unequivocality and there was no need to go to question whether or not the test should change. But this is the first time we've actually reached the stage where it is required to be considered.
Correct. The decision of Regina versus Byrd was ultimately overturned by the Supreme Court based on the dissenting opinion. However, it was because of a lack of evidential foundation for the defense. At no point was there any discussion as to a proportionality element that was required. This is, as I previously stated, this is not the first time that the Supreme Court has had the opportunity.
Counsel, is it your position that neutralization would require a positive step, or is it possible that neutralization could happen through a failure to not acting instead? Is a positive step required?
That would depend on the circumstances of the case. In most cases, in order to undo one's involvement, logically it would require some type of positive action to take back steps that have been taken to facilitate a crime.
So, and following through on that logic then, your issue with this additional test is that it requires positive action, whereas in the previous test, no positive action is required. Is that a fair formulation?
The appellant's issue with the four-step test is that it was applied unfairly to Ms. Kathy Gautier's evidence. At the time of her trial in 2009, when she first attempted to raise the defense of abandonment, it contained three essential elements. It did not contain the fourth element of neutralization. Should the law require this fourth element of neutralization be present within the defense of abandonment, she must be given the opportunity to present evidence as to steps that she took to neutralize her involvement. Steps beyond...
Counsel, what evidence would she provide, given that everything she could have done to neutralize would have been relevant to strengthening her abandonment claim, not just to pass the reality test, but to convince a jury that I actually genuinely didn't want this to happen?
I will answer your question in two parts. Firstly, based on the facts that are present in the case, there is an air of reality to the element of neutralization. We can identify some evidence that supports that she did take steps to not only withdraw and abandon the crime, but to also undo her participation. Secondly, we simply do not know if there is possibly more evidence that she could put forward to further support the neutralization element of the defense. As I stated, at the first time of her trial in 2009, the defense of abandonment simply did not contain this element or this proportionality idea.
So, counsel, perhaps my biggest concern is with the fourth part of your submission regarding the fact that while this is a precedent-setting court, we shouldn't employ this fourth stage of neutralization, because from where I'm sitting, we can imagine a situation where an individual hands over a gun and quite meaninglessly says, "That's it, I'm out," when their job, their role within that criminal enterprise had really been completed. So in that situation, this individual would not be found liable under the White House test, but would be found liable for the criminal enterprise that he or she had been a part of under this formulation of the test with the fourth element. And for that reason, perhaps, would you agree that the public policy is actually behind the neutralization element?
It is the appellant's position that the neutralization element is a highly subjective element that must be answered by a jury. It cannot be a matter of law analysis. To address the hypothetical situation that you proposed, there will be some circumstances when neutralization is simply not possible, and somebody who has in fact withdrawn their participation from a crime has unequivocally communicated that they will no longer proceed, that they will provide no further aid and assistance, and for whatever reason cannot take neutralizing steps. There are possibilities that somebody in that situation can be left vulnerable to a wrongful conviction simply because they could not satisfy the neutralization element by law.
So, counsel, you mentioned that there is already some evidence on the record for neutralization. Could you tell me precisely what evidence that is?
Absolutely. After Ms. Gauthier unequivocally withdrew her participation in the planned offense, she tore up documents in front of her husband. She did this as an act of nonverbal communication of withdrawal, but as the appellant submits, also as steps to neutralize her involvement in the pact. After all, the document that she tore up was a handwritten will. It was a will that she herself had written.
Counsel, just, first of all, I don't think we know if necessarily it was in front of her husband, but second of all, they still had an electronic version of the will. Couldn't it have just been a draft copy of the will that was torn up? Does this really show a positive step?
The typewritten copy of the will that you are referring to was signed by both parties. However, we do not know if in fact Ms. Gauthier read the will before she signed it. It could have been an altered version of what she wrote herself. And as the appellant has already stated, it is extremely probative evidence that she tore up the will that she herself had written as...
Wouldn't it have been far more convincing had she ripped up the one she'd signed?
Your Honor, I notice that I am approaching the end of my time. May I request a few more minutes to answer your question and to conclude my submissions?
Yes.
Thank you. To address your question, the appellant maintains the position that it is extremely probative evidence that she tore up the handwritten will in front of her husband as a way to tell him, I do not want to be a part of this, and we cannot continue with this, and I am undoing partially what I have done. Whether or not this is enough to determine that she had neutralized her involvement in the planned offense to that point is a question that must be answered to the jury. It is a matter of fact analysis that must be left to the jury to decide. To conclude, Your Honors, Ms. Gauthier has provided the courts with evidence that gives an air of reality to the elements of unequivocal communication and neutralization. From the trial stage, this defense should have been left to the jury. Since Ms. Gauthier was not afforded this opportunity, we are respectfully requesting that the Supreme Court of Osgoode Hall overturn the conviction and enter an acquittal. In the alternative, should this court not find reasons to overturn the conviction, we respectfully request that the matter be remitted to trial so that Ms. Gauthier may present new evidence as to the steps she took to neutralize her involvement. Barring any further questions, that concludes the submissions on behalf of the appellant, Ms. Kathy Gauthier. Thank you.
Thank you.
Good afternoon, Your Honors. My name is Rachel Abrahams, and my co-counsel is Juliette Mueller, and we represent the respondent, the Crown, in this matter. The position of the respondent today is that the Supreme Court of Canada correctly articulated and applied the test for the defense of abandonment. We have two submissions for the court today. The first, which I'll be presenting, is that the majority was correct to add neutralizing effects to the defense of abandonment in the case of Madame Gauthier. And second of all, our second submission, which my co-counsel will be presenting, is that there was no air of reality to Mrs. Gauthier's defense, whether or not we consider the neutralizing effects. If I may begin with my first submission, requiring neutralizing steps is not a substantive modification to the defense of abandonment. I submit this to the court for two primary reasons. The first of which is that the defense of abandonment has always been a contextually sensitive defense. Upon its conception in the case of the Crown and White House in 1940, it was stated by Justice Sloan, and I quote, "I would not attempt to define too closely what must be done in criminal matters involving participation in a common unlawful purpose to break the chain of causation and responsibility."
But why is that a good proposition of law defined too closely? Wouldn't that then depend on the facts and the level of participation? Somebody plans for 6 months to murder her children, and somebody plans for 6 minutes. Somebody buys poison, somebody else buys a chainsaw. Shouldn't we have clear direction, a bright line rule about when to charge the defense of abandonment and instruct the jury and when not to?
Well, Your Honor, I submit to the court that if this defense of abandonment was not contextual, it would be impossible to consider the specific circumstances of a particular offender's crime. It's vital that this defense considers what a particular offender has done to break this chain of causation and responsibility. A one-size-fits-all test would simply not suffice, because in this case, those convicted would not have a trial that was tailored to their individual offense.
Counsel, isn't the Supreme Court majority articulating an exhaustive list, a one-size-fits-all approach in their 4-step analysis?
Well, what I am submitting to the court to this respect is that by having neutralizing effects in the defense of abandonment, this defense of abandonment will be, in certain cases, that neutralizing effects will be necessary, and in other cases, perhaps the neutralizing effects will not have to be the same concrete nature that they will have to be in the case of Mrs. Gauthier. To elaborate on this, I would bring Your Honor's attention to the fact that Mrs. Gauthier's crime is a Section 21, subsection 1 crime of the Criminal Code. In the Criminal Code, there is...
A, B, or C?
Pardon me?
21-1, A, B, or C?
Her crime is a 21-1 subsection B crime.
Aiding.
Yes, she aided in the commission of this particular crime. I submit to the court that there is...
Counsel, so I just have a question. To me, an unequivocal communication would be a form of neutralization, especially when it's a communication to the eventual perpetrator. You are neutralizing it by attempting to persuade the eventual perpetrator to not do the action. So insofar as those two would be the same, an unequivocal communication would count as neutralization, it would seem to me to be a bit redundant to have a separate test, have separate point, which just duplicates one of the other points. Isn't it better law to have less points so that we don't have to have this duplication?
Your Honor, respectfully, I disagree with this, because for those convicted under Section 21, subsection 2 of the Criminal Code, who have shared a common purpose with the principal offender, for these people, they have committed to dedicate resources and support to the principal offender in commission of this crime. For these people, communicating unequivocal withdrawal can be said to be sufficient, because in this case, by communicating their withdrawal, they are effectively reducing the resources available to the principal offender.
Counsel, are you proposing 2 different tests in that case then? One for 21-1 and a separate one for 21-2?
No, Your Honor, I am not submitting this to the court. What I'm submitting is the fact that under the umbrella of neutralizing effects, for those who have committed an offense or have aided and abetted an offense in which their actions in this offense are not in fact concrete, but rather are a promise to commit resources, for these people communicating their unequivocal withdrawal can be considered to be a neutralizing effect for their participation. However, in the case of those convicted under Section 21, subsection 1 of the Criminal Code, such as is the case of Mrs. Gauthier, they have committed concrete acts in support of the commission of this offense. So for this reason, there are neutralizing steps that must be taken to effectively withdraw from their participation must be proportionate to the acts which they have committed in support of this crime.
So by proportionate, do you mean, it's very interesting. You were talking about resources, so someone dedicated resources, potentially, then their neutralization has to be proportionate, but by proportionate, do you mean that it has to do with those resources? So she would have had to have flushed the poison down the toilet. Would it have to do with those resources, or other things? Maybe being more forceful with him could have sufficed, but the communication isn't sufficient as it is. Just help me with that. What's the relationship between the neutralization and the resources specifically?
Your Honor, I submit that in the case of Mrs. Gauthier, because she performed concrete acts in support of this crime, including buying the murder weapon, which was the medication, Merely a communication of withdrawal to her husband is not sufficient to undo what she committed in support of this offense.
How is someone supposed to know what is proportional? How are they supposed to be confident that they've sufficiently reduced their culpability? Is it enough for her to take the kids to a neighbor for a few days and then when she comes back, then he kills them? Is that sufficient to be proportional? Because she undid it on that one day? How does someone know whether they've done enough?
Well, Your Honor, I submit to the court that if a particular offender truly wishes to withdraw from participation that they have had in a particular crime, they will do everything possible in their power to withdraw from this particular crime.
Well, look, that's not the bro. We're all going to jump down your throat on this one. That's not the requirement here at Canadian. Look, picture you're Miss Gauthier, okay? You've sat down at the table. The drugs have been purchased. The wills have been written up. The documents have been drafted, and all of a sudden you have a change of heart. And the internal conversation you're having with yourself is, what's the minimum I need to be able to do to withdraw from this? Because I don't want to do more than I have to, because maybe my husband's a murderer after all. Maybe he's gonna beat me up, or he's going to intimidate me, or maybe I don't want to make him disappointed. So how is Miss Gauthier supposed to know what the minimum amount of work she has to do to withdraw is? Should that be clear to her? Let's assume that she's like smarter than 40% of the Supreme Court of Canada, and she knows what the test is for abandonment, and it's the test that you're telling me about. How is she supposed to know what the minimum is?
Well, Your Honor, I submit to the court that in terms of policy reasons, if we look to the fact that we only want to let those escape punishment who are not sufficiently morally culpable, if we are looking at someone who merely wants to scrape by with the minimum possible to escape a certain offense, this is not sufficient. This person would still be morally culpable.
There has to be a minimum. There has to be a bare minimum that would meet this test. So what is that?
Well, Your Honor, that depends on the specific facts of a given case.
Because if she neutralized completely, there would be no murder prosecution at all anyway.
Your Honor, what Mrs. Gauthier must do is neutralize what her particular involvement was in this crime.
Completely, unequivocally, neutralize. Timely, everything.
Yes.
Otherwise the case doesn't even go to the jury?
Well, Your Honor, it is the role of the judge in this matter to determine whether there is evidence upon which they believe that a jury acting reasonably could acquit the accused if his evidence were believed to be true. And I'm submitting to the court that in the case of Mrs. Gauthier, because the acts that she committed, what she did to attempt to withdraw from this crime was not proportionate to the acts that she committed in support of this crime. So for these reasons, it is not justifiable to say that she withdrew from this murder-suicide pact.
So you want a very high standard on the abandonment defense to include neutralization, and you want a lot of facts showing neutralization, or the jury never even gets to consider it. That's your position?
Well, Your Honor, it is necessary that there is this high bar. Otherwise, those who are not sufficiently, as I said previously, those who are, Your Honor, it's come to my attention that I have run out of time. May I have a few minutes to proceed with my submissions?
Yes, Counsel.
Thank you, Your Honor. Madame Gauthier would have had to proportionally withdraw from this in order to be acquitted. And furthermore, I would like to direct the attention of the court to the case of the Crown and Kirkness, in which it was said that, and I quote, commentators on the defense of abandonment appear to agree that a defendant will be held to a different standard depending on the degree of his participation in crime. Because Mrs. Gauthier...
Who said that? Was that Justice Wilson in dissent?
Yes, that was Justice Wilson.
Quoting a law professor?
I believe it was quoting Glanville Williams in this particular case. Mrs. Gauthier, furthermore, I submit to the court that adding neutralizing steps is not a substantive modification, and rather that it reinforces the contextual nature of the defense of abandonment that is being instated since the time of Whitehouse. Furthermore, I submit that in several cases we have seen the need to perform actions that are proportional to neutralize what a particular offender has done in support of a crime. This was seen in the case of the Crown and Bakar and Cooper, in which it was held that the appeal for the conviction of brutal murder failed because if the particular defendant wished to withdraw at this stage, they would have had to do more than merely communicate an intention. They would have had to neutralize these acts.
Counsel, I'll just give you one more question, and then I'll ask you to conclude. If I'm Ms. Gautier's counsel before the trial, I'm looking at all this jurisprudence. All I see is a case of Fournier where it did get put to a jury, and an obiter comment in dissent in a very obscure case of Kirkness. How do I know that I need to bring up neutralization? How is this not something that's been completely blindsided me after the fact?
How do you know that you bring up neutralization? Well, in the case, first of all, in the case of Fournier, in which you just raised, in this case, we can say that the communication was unequivocal, and that's why it was brought to the jury, in the sense that this was actually a physical message on a recording device.
But it was very clear that it wasn't neutralized. In fact, the assassin never even got the message. And it was put to a jury despite the lack of neutralization.
Yes,
And it was just one word, cancel.
Yes.
There's so much more here.
Your Honor, in the case of Fournier, however, there is actual evidence that this occurred by the fact that we can hear this message. In the case of Mrs. Gautier, we cannot say that the communication that she had with her husband was unequivocal by merely the fact that she gathered from his facial expression that he understood her. From this case, I submit to the court that the facts of this case are not concrete enough for a judge acting reasonably to assume that a jury could acquit the accused based on these facts. To submit my position in this matter, I submit that adding the additional element to the defense of abandonment was not a substantive modification to this defense because of the fact that since its conception, it has been a contextual test in nature, and furthermore, for the form of participation of Mrs. Gautier's specific Section 21, subsection 1 crime, it was necessary. I now yield the podium to my co-counsel to complete the remainder of our submissions. Thank you, Your Honors.
Thank you.
May I proceed? Good afternoon, Your Honors. My name is Juliette Mueller, and this afternoon I will complete the submissions on behalf of the Crown in this matter. My submissions have two elements. Firstly, that there is no air of reality to Madame Gautier's claims to defensive abandonment as it was applied under the newly formulated test laid out by the court below. Secondly, even if this court disagrees and decides that the Supreme Court erred in its formulation of the defense, this does not constitute a reversible error, for there is no air of reality to Madame Gautier's defensive abandonment claims, no matter how the defensive abandonment test is formulated. If a retrial is to be granted to Madame Gautier, a properly instructed jury acting reasonably would not be able to form a reasonable doubt with which to acquit her. There is no evidence under which they could conclude that she took reasonable neutralizing steps to counteract her concrete participation in this crime.
So if the jury wouldn't have enough of a basis to conclude beyond a reasonable doubt, why are you so afraid of giving the defense to the jury, and let's find out for ourselves? And in any event, I thought that the standard is whether there's an air of reality rather than whether it would constitute a defense on credibility issues on a beyond reasonable doubt question.
Well, Your Honor, a trial judge is allowed to engage in some limited weighing of the evidence in order to determine whether it would be a waste of time potentially to send this to a jury.
But unlimited weighing means, if I use the alibi defense and say I couldn't have done it because I was on Mars, realistically, nobody's ever going to believe that because it's unbelievable. Certainly it's believable that she had this conversation with her husband.
In our submission, Your Honor, it's unreasonable for Madame Gautier to have concluded that she had successfully dissuaded her husband. Her communication surrounding her...
Why? The proof was unrebutted. Her husband is dead. Nobody testified to the contrary.
That is true, Your Honor. However, there are certain elements, certain factual elements that point to the fact that her communication to her husband was equivocal. Furthermore, her actions surrounding her withdrawal were unequivocal. Madame Gauthier only tore up 2 of the documents that laid out the murder-suicide plan, and she left a number of typed documents that still remained intact.
Counsel, she said, I don't want that. It was crazy. I ripped up the papers. I said, that's crazy, and I told Mark we couldn't. I told Mark he couldn't do that, and I didn't want to be part of it. It's your submission that this is equivocal?
Yes, Your Honor, it is our submission that this is equivocal for 2 reasons. Firstly, Madame Gauthier claims that she gathered from his facial expression that things were all right. Her conclusion that he had been successfully dissuaded is thus tenuous at best. It's unreasonable for her to conclude from a facial expression that he had
Facial expression of her longtime partner with whom she lived and probably saw millions of facial expressions.
That is true that Madame Gauthier knew her husband well. However, she also submitted to the court that her husband had been acting strange that day. So it's reasonable for us to conclude this afternoon that his facial expressions may not have been expressing what he may have normally expressed. Furthermore, we must consider the effect of the communication upon the individual. Madame Gauthier's claim that she did not want to participate in the crime is tenuous, for she did not take all of the neutralizing.
But, I mean, Ms. Gauthier didn't think she needed to take the neutralizing steps. Ms. Gauthier's argument here is, I believe, I met the error of reality. In reality, I erred, but because, he ended up going through with the plan anyway. But I believe that the error of reality is met because I had no reason to think I would need to hide this poison. It was a complete surprise, a complete shock that I keep saying poison. It was medication that would be probably around the house, maybe not in those quantities, but it would be around the house anyway. So should we say Ms. Gauthier, from a subjective standard, from somebody who was, in a troubled mental state, she was preparing to kill herself, she had given away all her things, that it was reasonable for her to think the way she did? Should we look at her subjectively?
In this case, I think it's important to consider the big picture. There were 4 lives hanging in the balance in this moment: the life of her husband and the lives of her 3 children. If Madame Gauthier even had a shred of doubt as to her husband's dissuasion, she should have taken every single measure available to her to prevent the lives of her children from being taken. And as such, it is our submission that Madame Gauthier should have taken reasonable neutralizing steps despite her claims that she believed her husband had been dissuaded.
Perhaps that's fair, but when you outlined your submissions for us, you said that there's no error of reality under the new test. Isn't the fact that you're calling this a new test make it patently unfair to apply it to her retrospectively?
In our submission, it's not exactly a retrospective application of this.
Well, you're calling it a new test, so isn't that exactly what it is?
Perhaps I should clarify. I think a better assessment of the test would not be a new test, but rather a clarification of the previous test, a reformulation of it so as to make an element that was previously implicit explicit. The goal of the court in reformulating this test was to improve the test. We want to ensure that the test is as stringent as possible so that only those who are truly culpable can be held liable. Reformulating the test to make this an explicit element is an improvement upon the previous test, for it lays out precisely what an individual must do in order to meet the error of reality.
At the time the children were poisoned, did Miss Gauthier have the requisite mens rea to commit the crime? The guilty mind? Did she have a guilty mind at the time the children died?
Yes, Your Honor. Madame Gauthier was only in a dissociative state on December 31st, and she purchased the medication in a clear state of mind. As such, the mens rea was still there. She was in a clear state of mind when she initially conspired with her
But
husband.
she didn't have the intent anymore, and I think that's the issue here.
Yeah, I don't want to ask you about the dissociative state or anything like that, but what we're getting at is at the time the children died, did she have the intent for them to be poisoned?
No. However, that's not relevant in this case. We're not assessing whether or not Madame Gauthier had the mens rea. We're assessing whether she took the requisite steps to prevent her children from being murdered. And in our submission, she did not. In the minority decision below, Fish claims that, quote, failure to take neutralizing steps is not fatal. However, in the case at bar, It was quite literally fatal. Madame Gautier's failure to take neutralizing steps resulted in the tragic death of her 3 children.
If we have too high a standard, though, this might relate also to your co-counsel's submission, that will encourage people to go forward to the bitter end with their crimes and not to withdraw, not to abandon. What's the point in abandoning if I'm just going to be convicted anyway? Might as well go through with it.
The point of abandoning in that instance would be to absolve yourself of criminal liability.
Well, you wouldn't if the test was too hard. You wouldn't meet the test and you wouldn't get that, absolutely wouldn't get absolved of any liability.
Well, we're assessing whether an individual is morally culpable, and if an individual truly no longer wants to be morally culpable, regardless of whether they will be convicted or not, they will take all the steps that they deem necessary.
But it's not what they deem necessary, it's what the court deems necessary, and how do they know what that is?
I'd like to point the court to Crown and Edwards, wherein it was emphasized that neutralizing steps can serve a probative purpose in claims to unequivocal withdrawal. Now, my learned friends claim that Madame Gautier did not know that this was an element. However, she should have known that if she wanted her claims to defensive abandonment, unequivocal withdrawal to succeed, she should have taken every single precaution, she should have put her best foot forward the first time around in court and adduced every single shred of evidence that could have supported her claims of unequivocal withdrawal.
I think I echo the Chief Justice's concern on this point, that the public policy rationale of encouraging people to withdraw from crimes is actually undermined if you set the bar too high. So what you've done here is moved the goalposts and then applied it retrospectively to her, but more broadly, where is the social value in raising that bar, since it's really going to discourage people from withdrawing from criminal enterprises?
In our submission, it does not discourage individuals from withdrawing from criminal enterprises. All the reformulated test does is make explicit a requirement that has always existed in the White House test for 70 years now.
Well, it does make it harder. I mean, let's take, for example, somebody who's part of a gang. They give somebody a weapon, and afterwards they realize, like, oh God, I've done something I don't want to do. They're willing to go to that person and say, I can't help you anymore, but they don't want to go any further because it might get them killed.
Well, that's precisely why Justice Wagner, in the majority below, emphasized that there are certain situations in which neutralizing steps will not be required. Counter to what my learned friends have emphasized, this is not a one-size-fits-all blanket test. Rather, it speaks to what my co-counsel has emphasized, which is that this newly formulated test allows for this test to remain context-dependent, as it certainly should. It's essential for it to remain context-dependent. I recognize I've run out of time. May I briefly conclude?
Yes.
Thank you, Your Honors. I cannot stress enough the fact that if there was not enough evidence presented at trial to give Madame Gautier's defense an air of reality, this is not a reason to give her a new trial. Rather, precisely the opposite is true. It is a reason to reaffirm her finding of guilt. Madame Gautier, a woman who knowingly took part in the murder of her 3 children, failed to take any steps to counteract this action. As such, 3 of her children were murdered. In our submission, her claims to the defense of abandonment, no matter how the air of reality test is formulated, are meritless. As such, it is our submission that a retrial should not be granted to Madame Gautier. Barring any further questions, I yield the podium.
Thank you. Thank you very much, Mr. Monkhouse. Well, we certainly want to congratulate all 4 of you for your fabulous, fabulous arguments. I would like to say, Laura, that your organization and moot court style Jenna rather. You went with, I think you went with middle initial L and Laura, and I got, so it's Jenna. Your organization and your moot court style, really unparalleled. And Kate, such charisma and presence and composure. Rachel, responding to questions and addressing legal topics. And Juliette, good to see you again. Your use of facts and application of facts to law, just awesome. I've heard some arguments over the years, including moot court arguments. At one local New York law school, I was the moot court faculty advisor for 18 years, and I will say, without hesitation or reservation, that your arguments were as good as a final round in a national moot court competition of third-year law students, and as good as a very good seasoned advocate before an appellate court in the United States and also in Canada. There's so much for all of you to be proud of. I believe that you have represented the 106 teams of the Osgoode Cup with great, great distinction. I really have just one job in this moot court competition, and that is to announce the victors. I will tell you that it was a close call, not merely because we were discussing this for a little while, but because of the actual votes. 5 of us got to vote, and 3 of us voted one way, and 2 of us voted the other way. I'd like to offer my very great congratulations on a 3-2 vote to the appellant.